And welcome to the Week 7, Chapter 7 video lecture. In this chapter, we're going to talk about defense attorneys. Last time we talked about prosecutors. Now it's the chance to talk about the other side of the coin. Let's go through what we're going to learn about. We're going to first interpret the four major legal issues surrounding the right to counsel, which, by the way, is considered now a constitutional right, at least for felony cases. We're going to discuss how the courtroom work group affects how defense attorneys represent their clients, and we'll see that it has a very real effect, but not necessarily for negative reasons. And it's not necessarily an indication that that defense attorneys are selling out their clients, for instance. You'll see that when we get into it. We're also going to explain why most lawyers do not represent criminal defendants, because there's some real problems involved with that. We'll go over that. We're going to compare and contrast the three systems of providing indigents with court-appointed attorneys. And then we're going to recognize possible tensions between lawyers and clients that can come up, and they do, and I have seen it. Then we're going to analyze the importance of legal ethics to the defense of criminal defendants. Okay, we'll see how that becomes a very important part. Let's first start out with Gideon versus Wainwright. Very, very famous case. It's actually been part of a not TV movie, but actually a real movie, actually. And it was made sometimes probably in the 1970s, I think it was. Anyway, this was someone who represented himself because he didn't have a lawyer and he couldn't afford one. It was a felony prosecution. Clarence Earl Gideon, and he lost, went to prison, and then he petitioned, to get his conviction overturned on the basis that he should have had an attorney, and the United States Supreme Court agreed with him that under the federal Constitution, which was binding on the states regarding the right to a fair trial and the right to counsel, that if someone cannot afford an attorney for a felony matter, then the prosecution, not the prosecution, but the government must provide them with a competent lawyer at no charge. Indigent defendants have the right to a court-appointed counsel then, but applies only in felony criminal prosecution. So there are some states that don't offer it for misdemeanors, and some states that do. And it all depends on the state involved. But right now, the state of the law is, under the federal Constitution, you must give a court-appointed counsel to indigent defendants in felony criminal cases. Okay, not civil cases, and not misdemeanor criminal cases, but felony criminal cases. This decision sent shockwaves through the criminal justice system, because now every single community had to come up with a public defender's office where they would essentially employ counsel to represent indigent defendants, because many defendants were indigent, and you might imagine. And so a very strange system started blossoming. We had now prosecutors, which were paid for by the state, and now we had defense attorneys paid for by the state. So sort of a little justice there in a sense. All right, Sixth Amendment. Sixth Amendment has as part of it the right to counsel, and this Sixth Amendment right to counsel was extended to juvenile cases in re Gault in 1967, about 4 years later. And again, they have the right to counsel in even non-felony criminal cases, even though juvenile cases are actually not criminal. They're technically civil, even though they involve criminal conduct and beyond a reasonable doubt standard and so on. And the question becomes then, what stages of the criminal process do you have the right to counsel? So for instance, if it's before even filing a criminal case and you're trying to find out who did the crime, is there a right to counsel? Well, actually, we'll see that there is, and at least as to pre-filing interrogations and pre-filing lineups. Everyone has a right to a court-appointed attorney. Also, ineffective assistance of counsel becomes a real issue, because if you're required to give them counsel, you must be giving them competent counsel, not incompetent counsel. And that has brought up a lot of issues, because first of all, what is incompetence? That's the first thing. And second of all, when does it actually happen? And then what do we do about it? If you have ineffective assistance of counsel, you've had your constitutional rights violated, it's highly unlikely that you would not get a reversal on the basis of ineffective assistance of counsel if you can prove it. Also, there is an issue regarding whether someone can represent themselves, and often they are allowed to, as long as the court finds that they are competent to do so. And judges will often, especially in the bigger cases, appoint associate counsel to be there in case the defendant either changes their mind or needs a little help, just so that they can't later say that they were incompetent. All right, let's look at Augersinger versus Hamlin, Scott versus Illinois, and Alabama versus Shelton. In Augersinger, the Supreme Court decided, this is after they decided that for felony cases there was a right to counsel that must be appointed for indigent defendants. They refused to extend that rule to minor violations, including misdemeanors and ordinance violations, so that there is no federal requirement under the federal Constitution for there to be appointed counsel for indigent defendants for anything other than felony as of this moment. Okay. Also, in the Scott case, the court ruled that there is the right to counsel to indigent defendants in felony cases, but only if there's actual that it actually leads to imprisonment, not potentially leads to imprisonment. So it's possible you could still railroad somebody, so to speak, without an attorney in a felony case, so long as you're not going to put them in prison. Yeah, very interesting. That had a bit of a chilling effect, as you might imagine, on exercising the right to counsel when you're indigent, because you know, you could possibly get a deal for probation and some jail time, and you would not necessarily be entitled to an attorney if that's what happened. So it's kind of interesting how that worked out. On the Alabama versus Shelton, they did rule that indigents are entitled to a court-appointed attorney even if facing only a suspended jail term for a minor charge. So what happened is all these decisions came down to now even misdemeanor cases, not necessarily ordinance cases, but misdemeanor cases, even if there is no actual jail time, indigent defendants are entitled to a court-appointed attorney. So it kind of came step by step. First felony prosecution, then only if there was imprisonment, and then more recently it got down to misdemeanor cases as well. So, and regardless of whether there's any imprisonment or jail time. Okay. All right, let's think about the thinking point here. This is Justice Scalia. Research him and his rulings and his discussions regarding juvenile court proceedings. Think about, ask the question of whether or not the issues are fair and impartial. How do the issues relate to the adult system, and what cases are most current? And then let's think about those cases. For example, in Roper versus Simmons in 2005, Scalia wrote a dissent in the 5-4 decision that declared the execution of juvenile criminals to be unconstitutional. He took the stance that, as he did much earlier when he wrote for the majority, when it allowed states to use capital punishments for killers who were 16 or 17 when they committed the crimes. But in a very, very almost stinging dissent, he ridiculed the notion that states had abandoned capital punishment altogether. It would be included in the discussion about juvenile death penalty. It was a situation where he, being a very conservative judge, was now on the wrong side, so to speak, of that decision. He was on the dissenting side, and he, obviously thought that it's perfectly constitutional that certain aged juveniles, 16 and 17, for instance, just a couple of years before what other states will enact the death penalty for, should be constitutional. So think about his thoughts and his process there, because we're probably going to be seeing these kind of issues coming back up before the court as it's becoming more and more conservative over the past few years, and we're likely to see that capital punishment exclusion ruling from 2005 possibly being overturned. So think in terms of what you might think about whether that's fair or unfair, proper or improper. All right, let's look at the Sixth Amendment and the stages of the criminal process. Sixth Amendment applies to all criminal prosecutions, thus coined the critical stages test. So what the question was not whether there was a right to counsel, but when does it start? Because it could start perhaps before the proceedings are actually filed, before there's any case against somebody, which is true. The cases so far have said two things. If we're having custodial interrogation by police, according to Miranda versus Arizona, you have the right to counsel. If you ask for counsel, they must appoint one for you or not question you. Okay. Now, on the pretrial lineups, that's also been considered sufficiently critical to require there to be a counsel at pre-filing lineups. So this is very, very typical. You get a case where there's an eyewitness. We want to line up several people to see if they can pick out the person they believe is the culprit, that there's so much potential for someone being inappropriately identified, and then once identified, that witness will never get off their identification because for many different reasons. Not only would make them look like a fool, but they really start to believe that is the person. And there's very, very many bad decisions that have come up. We've found out about them later when more evidence came up that we had sent somebody to prison, even death row, on the basis of an incorrect identification, based on these misrepresentations or misleading ways in which people were lined up. So certainly, if adversary proceedings have begun, that means there's been a filing in a court of the criminal proceedings. Absolutely, the right to counsel now has begun. So so police, for instance, they will want to get a statement from someone before there is a filing, because once there's a filing, they have an absolute right to counsel. You can't even talk them under any circumstances until counsel agrees to allow you to. And so you're not, if you're going to get a statement from them, it's going to have to be before the filing, especially when it's custodial interrogation, and that will have to be when someone waives the right to an attorney and agrees to speak with you under Miranda. All right, so again, custodial interrogations, Miranda versus Arizona, police lineups is U.S. versus Wade, and Kirby versus Illinois. So very early on, these became very important rights to counsel, considered to have met the critical test. All right, so at the arrest, there's no right to a lawyer. It's not required. In the initial appearance in court, a lawyer is required. That's a critical stage. That's after a filing has taken place. Could possibly even be without a filing, maybe, but typically not, because without a filing, there's no case, and so far there's not been a decision that talked about someone still being under arrest and no filing has been made, but they were brought into court. That happens sometimes, by the way, because the person was supposed to be there at a certain time and the complaint hasn't yet been filed. Also, on the issue of bail, not ball, but bail, lawyers required. Certainly, that's a critical stage. Charging, certainly. At the time of charging, there is no right to a lawyer. Only when there has been a filing. That's not just charge them, but the charging usually is done by police. They charge them with certain crimes or suspicion of certain crimes. There has to be an actual filing. Preliminary hearing, of course, a lawyer would be required. That's after there has been a filing. A grand jury, no lawyers allowed if there's a grand jury proceeding. There's no right to a lawyer regarding the grand jury proceeding. So it's possible you could even have a filing. And whatever's going on in the grand jury, you're not entitled to a lawyer regarding whatever's going on in the grand jury. Also, arraignment. Arraignment that'll be arraignment after you've had a probable cause hearing, either through a grand jury or a preliminary hearing. A lawyer, of course, would be required. Certainly, interrogation for pre-indictment, there's a lawyer on request. So, in essence, you have to tell the suspect that they have a right to a lawyer, and if they request one, then you must give them one, or you cannot question them. Police pretty much know if the guy says, I want a lawyer, they're not going to talk after the lawyer talks to him, because the lawyer is going to tell him not to talk to him. There is absolutely, repeat, absolutely no reason why a lawyer would consent to someone speaking with the police at any time. No good lawyer, anyway. All it can do is give the police something they don't already have and make your life miserable. Okay. Interrogation post-indictment, a lawyer is definitely required. If there has been a filing, a lawyer is required. End of story. It doesn't make any difference what stage it is. Once that filing has been made, a lawyer is required. You cannot have interrogation without that lawyer there. Lineup, this is pre-indictment, pre-filing. No lawyer is typically required, but certainly post-indictment, yes, but even pre-indictment can be required. Depending on the circumstances, it can be required. And in plea bargaining, of course, you would have definite lawyer because that's after a case has been filed. I would like you to note on the Kirby versus Illinois case that this chart here is correct. There is no lawyer required under Kirby versus Illinois for pre-indictment. That means there's no charges at all anywhere. Lineups. Okay, it's not required. Your book says that it does require it, so your book is incorrect. It's incorrect in the text, but it's correct on this chart, so I wanted you to be aware of that. Kirby versus Illinois, actually look up the case, you'll see it. They stated that there is no obligation to have a lawyer. Now, it would be a very good idea that a lawyer be there, and some public defender's offices, ones in my area in particular, will do it voluntarily, and the reason for that is because of the fact there can be such circumstances that could get a pretrial identification done inappropriately. Okay, so that's a real problem. Certainly at trial, lawyers required. Sentencing, the same. Probation revocation is it's at the court's discretion because probation revocations are actually considered civil matters. They are not criminal matters. It's just a matter that it's just a civil proceeding to see whether the court will find that there has been a violation of the court's probation order or not. And same thing for parole revocations. It's a civil matter, not a criminal matter, so that's why there is no right to a lawyer. On the first appeal, there certainly is a right to a lawyer. Discretionary appeals, no lawyer is required, so we don't have to give them one for a discretionary appeal, although they will often go ahead and do that for a defendant, especially in death penalty cases. Let's look at ineffective assistance of counsel. So, first question you ask is, how do we determine that there's been ineffective assistance of counsel? Because if there is, then the person has been denied their right to counsel under the Sixth Amendment, and therefore there should be a reversal of the case, just as a matter of right, because you just can't defend yourself without competent counsel. There's just no two ways about it. So what we do is we use an objective standard of reasonableness, and what this means is that we look at what the counsel did, and we looked at two different things. One is, was it a tactical consideration by which lawyers can make many different types of decisions. If it's one of those very discretionary kind of things where a certain tactic that you take on how to defend a case, if it's that kind of thing, it's highly unlikely we will find ineffective assistance of counsel. If, on the other hand, counsel doesn't call a material witness, just forgets or makes just a stupid decision not to bring up somebody that could help the defendant, then that can be another matter, probably very likely ineffective assistance of counsel. So, we under Strickland versus Washington, with the questions that they asked, that they have to be answered affirmatively in order for there to be a finding of ineffective assistance of counsel, is first, did counsel's conduct undermine the proper function of the process? So, in essence, did it really, make it so that this poor guy didn't get a fair trial because something happened something either happened that shouldn't have happened, or something didn't happen that should have happened? That would be in the normal course of just anybody defending themselves in a given case. Then most likely this answer would be affirmative. And number two is, did it render the outcome unfair? In essence, did the person not get a fair trial as a result of whatever problem there may have been with counsel? If so, and if that's affirmative, then you've got yourself a finding of ineffective assistance of counsel. You're going to have the case reversed as a matter of law, because the violation is you can never undo an unfair trial. You can't make it better. There's nothing you can do. The trial's over. So you have to retry it again. Appellate courts must reverse if the proceedings were unfair and the outcome would have been different if counsel had not been ineffective. So in essence, there's a bit of a practical thing here. They could say, okay, yes, you forgot to call this one witness, but it would not have made any difference to the case. Then there's no ineffective assistance of counsel. I mean, there was actually ineffective assistance of counsel, but it will not result in a reversal. It will result in an affirmation of the decision because he's been given a fair trial. In essence, you're not entitled to a perfect trial, you're entitled to a fair trial. There have been a few appellate court reversals on these grounds of it actually changing the outcome. So it may or may not actually happen, that even when there is really ineffective assistance counsel, it may not result in a reversal of the case. Let's look at self-representation. Defendants have a Sixth Amendment right to self-representation. It's called pro se or in pro per. Those are just Latin terms that says you're representing yourself. Essentially the limits, according to the cases that we looked at, the limits are you must show the judge the ability to conduct the trial. If you are mentally ill, for instance, it's not going to happen. If you are just an idiot that wants to represent themselves, you have a brain, you can sort of figure out the law and so on, maybe they'll give it to you. Standby counsel is usually made available during the trial, especially the more serious the case is, more likely the court will appoint standby counsel who will be there the whole time, knows all about the case, knows exactly what to do, but then has to wait and be asked questions by the defendant because that counsel doesn't actually represent the defendant at that time. Let's look at some of the thinking points in self-representations. Let's assume you've just been arrested for armed robbery of a bank. You decide you will represent yourself. Let's come up with some defenses to your actions. Let's present these in class. Allow you to now ask questions. I want to allow you to ask questions, but let's discuss your overall experience and why you would even want to defend yourself. You know, one of the problems of defending yourself is you're going to have to get up in front of the jury and argue your own credibility. Perhaps if you're going to testify in the case, you're going to have to tell the jury, well, you obviously I'm credible because that's who I am. Well, wait a minute. It would be better if someone else were saying that because it would have more effect than you, because you're someone who wants to get out of the charge, and that's who they're listening to. Also, your arguments are not likely to be as effective because you probably have never argued a case before a jury, and you may not realize some of the problems that can come from making the wrong kind of argument that kind of messes them up, or not making the right kind of argument that would have helped dramatically in them coming to a not guilty. Okay, one of the more interesting aspects of defense attorneys is their position in the courtroom work group. Remember, the courtroom work group is the judge, the prosecuting attorney, and the defense attorney. And it may also sometimes include the probation officer. This work group works together to try to resolve cases. That's the reason why they call them a work group. They're actually getting together for the purpose of seeing how many of these cases they can deal out without a trial. You would think it's in everybody's interest that you get as many of those as you can, and it's certainly in the court's interest because they don't have enough time, they don't have enough courtrooms or judges to ever try every case. It's just never going to happen. And I gave an example in some of my previous video lectures of a situation where we had 12 DUI misdemeanors that had to be tried within the 5-day week, or they would be time barred. And how the defense attorney was a public defender, and so she talked all of her clients into insisting on going to trial on every single one of them, and put us in a real bind because some of them were going to drop out. So the judge and I got together. We were going to do 3 of them a day. We're going to get them all done in a 4-day week. And we did the first 3 DUIs in one day. We didn't finish until midnight. After having one jury come back at noon, one come back at 5. And one in the morning started about 8 or 9 in the morning, and did the same thing for the next day. And after the 5th trial, the public defender got tired, and they waived time on all the rest of them for another day. But that can happen, and these cases can be gone. And once a misdemeanor is dismissed, it's dismissed forever, can never be brought back. So those people would have gotten off on those charges on the basis of simply not being able to try every case. So you can see how that can work. All right, so the defense attorneys have a different kind of position. Let me try to explain it from the point of view of the defense attorney. The defense attorney, they feel a little bit for their client. They may know their clients are sort of bad people, or at least they do bad things, and they don't like what they do, and many times they confess to their attorney, and so it's not even an issue as whether they're guilty or not. And so the real issue is, what do I do for this person? Well, one thing that the defense attorney does not want to happen, and that is for them to give the advice to go to trial. The defendant loses and gets some huge, surprising, gigantic sentence that basically ruins their life. That one will make a defense attorney turn white. All the blood will drain out of their face, because it's like, oh my God, look what I just did. I didn't give them the best advice, and look what happened to my client. They're very much afraid of that. They very much know that if they go to trial and they lose, they will get more time on their client than would happen if they're able to negotiate a plea disposition. And they also have a pretty good idea of how many years or what kind of penalty is going to be assessed against them if they go to trial. And then they also have a pretty good idea of how provable or non-provable the prosecution's case is. So let's just assume we have a pretty much 100% chance that the prosecutor is going to win, so that's not even an issue. Let's say he's looking at 15 years if he goes to trial. That's a likely sentence, because other cases that have gone to trial with very similar results, very similar aggravating and mitigating factors, have had 15-year sentences. Okay, now we're looking at 15 years. This defense attorney is looking to deal this case at anything less than 15 years, and to advise the client to take the best deal they can get, because anything less than 15 years is a win. Okay, so that's the mindset of the defense attorneys, and what they don't like, again, is to give the advice to a client and have them go along with it, and then the worst thing happens. They get much more than they ever would imagine they were going to get. And that's also a possibility. Sometimes these judges will throw the book at somebody you really don't know. There's a little bit of, sort of a, like a, I don't know, kind of a anomaly that might happen, where not 15 years, you get 25 years. You just hit the judge on a bad day, and once the trial's over with, the court has absolute discretion on sentencing. So there's nothing you're going to do. You argue yourself till you're blue in the face. It's not going to stop a 25-year sentence if that's what the judge wants to give him. Okay? So winning is doing the best for the client. That's their definition of winning. And what is best for the client depends on, first, the provability of the case, and what is the likely result if they go to trial. So let's do this. Let's think about, now you're a defense attorney. You're going to be doing many, many, many of these things, especially if you're a public defender, because that's all you do. You just do criminal matters all day. So you wonder whether you should cooperate in this courtroom workroom or not, and based on your experience over, let's say, a year, it takes you about maybe that long before you really figure this out, maybe, but you will figure it out. When you're cooperative, there are rewards. Number one is you get access to information maybe that you couldn't have gotten access to before. People work with you more. They go out of their way to help you when they may not have done that otherwise. You will deal out more cases and have fewer trials to do, and trials are very stressful events. So you get those kind of rewards. Sanctions that might be against you is that you may get poor scheduling. You may be involved in a lot more trials. You may get many fewer offers from the prosecution. If a prosecutor wanted to sanction a defense attorney, they might say, I'm not giving you any offers. You're not getting anything. We're all going to trial in every one of your cases. That would be disastrous for the defense attorney. Of course, it could be disastrous for the prosecution too. They can only keep that up for so long. But the judge could also say, hey, you're a maverick. You're kind of going out on a limb here, and I'm just not going to help you very much. The last thing you want is, in the mind of the judge, some negative impression of the defense attorney because that could end up reflecting on the judgment of that judge at time of sentencing if you do go to trial. Yeah, that shouldn't happen, but it will, and you know it. So those are sanctions. More direct ones are criticism, a lack of assignment of some cases. You might, judges can call up your supervisor and say, this guy's a maverick. He's not cooperating in the work group. I'd like you to send him to do juvenile for the rest of his career, which is not a very nice assignment. And no more felony cases for this guy. And that might happen. So, yeah, you might still get paid the same amount, but you now have to go do some cases that are just, I don't know, they're just not as fun. Let's put it that way. Or not as, fun's probably not a good word, but it's certainly not as much enjoyable. You're not going to do as much. You don't think you are. And it's just, you get more work than you could possibly do. And then there's tougher plea bargaining. You're not going to be able to get the kind of deals that you could get for your clients. You're cooperative. Someone may give you something a little here and there because you're cooperative. We'll give you a little extra. It happens. It's just normal. That's how people who are cooperative work together. That's another thing, another reason why you might want to be part of this courtroom work group. So the variations in cooperation, inexperienced attorneys will tend to want to go to trial more often. They think that's the way it should be, and then they get this idea that, wait a minute, I've gone to trial too many times because I've talked my client into going to trial, and they ended up getting twice as much sentence as I thought they were going to get, and I had to explain that to my client after the fact, and I didn't like that. And that's kind of what we're dealing with here. Also, if you're a gambler, you have a gambler's kind of mentality, you might want to take to trial more often. Because why? Because not every case is 100%. Very few of them actually are. They may be in the 90% range, but some of those get lost. And I've seen it happen. I've lost trials I shouldn't have lost. I occasionally will win a case I thought I shouldn't win, but more often I will lose one that I didn't think I should have lost. And it depends just on the public defender themselves, whether they are a public defender or they're a private attorney. It makes a big difference as well. If you're a public defender, you're going to be in those work groups all the time. If you're a private attorney, you may not be there as often. You may have bigger cases, fewer cases, and it may not be in the same court all the time, but public defenders will tend to be in the same court for a very long time. They may get a different assignment to a different judge later on, but it could be years. And then, so let's assess this. Should we be cooperative? Should we be mavericks? What should we do when it comes to that? That's a very, very difficult question, but one that you could certainly justify cooperating because you're trying to get the best deal for your client. And in cases where it is a true gamble as to who's going to win the case, it's perfectly okay to be going to trial. Those are the ones that should go to trial, the marginal cases. Let's look at the criminal bar. There's a big diversity and stratification of the legal profession. Criminal matters tend to be considered low status, meaning, you're dealing with people who are kind of, well, they're criminals. They better be, or because the prosecution's not doing its job very well if they're not. And you get paid. You might get paid well, possibly, but look who you're dealing with. Look who you have to bring into your office. You've got this beautiful mahogany paneled office with Persian rugs on the floor, and you're bringing in these people who are like low economic status people that you look at them and you say, oh my gosh, what are you doing here in this place? It doesn't sort of fit the impression of what lawyers typically do. They typically have very rich clients. That's why they have very rich accoutrements in their offices and so on. And so you don't look really good to other lawyers. And also, you don't make as much money as other lawyers. That's a fact. Civil practice tends to be much more lucrative than criminal practice. Also, there's difficulty in securing clients. Not every client can afford to pay you if you are a private attorney. And usually, you can't take an hourly fee from people and have them pay you by the hour. And you cannot leave it to where someone has to pay you money for two reasons. One is they're probably going to be going away to prison. And number two is you're never going to get your money out of someone who doesn't have any money unless mom or dad or some relative puts up some cash to buy a good attorney. And so you're going to take all your money up front. or you're not going to take the case. So you're going to get many fewer cases as a result. I'm sure everyone would love to have an attorney for free, and they may, say, I'll pay you, but they never do. You can't make a practice that way. And then the fees tend to be very low versus the amount of time that you put into the case. And so, again, you don't do as well as you could do in other aspects of the profession. Now let's look at providing indigents with attorneys. First, there's appointed counsel. The indigent means that they are too poor to pay for an attorney and are entitled to have one for free. 75% of state prison inmates have a court-appointed attorney. In urban courthouses, 82% of felony defendants are too poor to hire their own attorney. And it's up to the counties to determine what kind of system they will utilize to specifically decide on that issue. Because sometimes someone could be a homeowner, but they don't have the cash to come out of pocket, and they can't get it in a short period of time to pay a lawyer to do it. And sometimes the judge will give them time to see if they can find a lawyer, and then they go to find out, how many lawyers did you contact? What fees did they ask for? How can we get that, the fee out of the equity in your house? So essentially, if there's time involved, time that will be allowed in the court proceeding, the court might try to find a way to get them to, mortgage their house to pay for the attorney if they could, but you can only go so far, and the system can only wait so long. So if you can't get that money within a reasonable time, you're going to be given an appointed counsel. Now, assigned counsel, these are attorneys appointed by the judge on a case-by-case basis, and that they would typically be private attorneys. There's also contract systems. Attorneys are hired to provide services for a specific dollar amount, and they are contract public defenders, more or less. And so they come in and they do public defender work, but they do it under contract. So they're not actual government employees. They are private attorneys, but they're paid under contract. And then you have public defenders' offices that are salaried public official type attorneys, and they represent all indigent defendants, and they get more work than they can possibly do typically, but they are just like prosecutors that also have more work than they can do, based on my experience. Also, assigned counsel, most common in small counties where you just can't afford to be hiring attorneys as government officials. You got to pay them all sorts of pensions and benefits and all sorts of things. It's cheaper to hire them by the hour if you have a small number of cases. Criticisms of the assigned counsel, they typically are the least qualified attorneys because you're paying the lowest amount that you could imagine. And so only the ones at least qualified and the most desperate are going to be taking these assigned counsel roles. So within an inadequate pay, they're not going to probably do as good a job because they're not being paid very well as well. So they tend to be a little lazy, which is not good because you have to have effective assistance of counsel. So there's a chance that this could create that kind of situation where you don't have that. Some of the contract systems, again, most common in small counties. In fact, in Santa Maria, in California, where I practiced, there is a contract public defender, but that was only for where there was a conflict of interest by the public defender's office, because there was a public defender's office there. Some of the criticism, again, for contract systems, that there's a lower standard of representation due to bidding. In essence, you're giving it to the lowest bidder. They will bid, for so many hours of work or whatever it is, and you get the lowest bid, and so you're getting the lowest and most desperate of the attorneys. Private bar no longer plays an important role in indigent defense because of that. It was also found unconstitutional in Arizona, the contract system that they had, because it was essentially guaranteeing an effective assistance of counsel. Now, public defenders started in Los Angeles County in 1914, actually. Today, the public defender system represents about 70% of all indigents nationwide. They are public or private nonprofit organizations that also represent indigents. ACLU will sometimes come in, for instance, as a private nonprofit. Funding occurs at the state or local level for these people because the state does most of the work. Now, if it's a federal prosecution, it'll be at the federal level. Courts, controversy, and economic inequality. Are we spending it too little or too much on indigent defense? Essentially, what do you think about that? Can it be that we give these people, either public defenders or contract public defenders, too much work, don't pay them enough, they just don't do as good a job as they could? Is that what's going on here? Do you agree more with the due process model or the crime control model on indigent defense? Well, if you're going to do the due process model, you're going to be paying a heck of a lot more. and you're going to make sure every, you're no stone is unturned to defend every single person. Crime control models say, give them what you absolutely have to and nothing more. They're obviously guilty kind of mentality, or the vast majority of them are. And so why are we spending a lot of money? Assessing the merits of the public defender, some of the proponents say that they devote more attention to clients, which I think is actually true based on my own personal experience. They are more experienced in competent counsel. I will also agree with that because that's all they do. They know this stuff. They're trained. They have continuous training all the time. They know what they're doing. Now, that doesn't mean they don't have too many cases. That's one thing that's a problem. And there's a certain amount of continuity and consistency here in that your public defender is going to take you through the entire process, and there is a certain amount of merit to the fact that you're getting one lawyer to go through the whole process. They get to know you, and they know your case better. Some of the critics say it's tied too closely to the courtroom work group. Well, that's true, but that's a discretionary decision by the public defender, and again, motivated by getting the best deal for the client, which is what they should be doing. Let's look at lawyers and clients. First, lawyers act as advocates and counselors. Their communication with the client is privileged. Very rarely will you find that privilege ever being invaded. The only time it likely would ever be invaded is if the person is talking about a future crime rather than past crimes. If that's the case, then the lawyer has no such privilege, or the client has no such privilege, and the lawyer can be forced to testify as to what the client said. Lawyers' view on their clients, there's a frustration due to difficult clients. There tends to be a lack of trust, lots of evasions, deceptions, failure to take advice, kind of thing going on by the clients towards the attorneys, not the other way around. In fact, I remember a public defender who became a judge, and he was talking at one of our breaks, and he just said, most of your clients don't trust you, but, go visit them at Christmas at county jail, and they will be eating out of your hand. In essence, they will trust you with their lives because they know you care about them. Because they don't think you care about them, and that's why they don't trust you. They will sometimes evade or try to evade telling you the exact truth about what happened and cause you to not do as good a job because you don't know what the truth is. They will deceive you, and they will also sometimes not take your advice. So if they don't take your advice, maybe you can feel like you're absolved of any obligations in terms of what may happen to them. Defendants' views on their lawyers, they're skeptical about their skill. It's very common, by the way, at arraignment court for the judge to say, okay, well, we're going to appoint the public defender to represent you, and the client will just blurt out right there in the court, no, judge, I wanted a real attorney. And everyone will start laughing. And the judges will say they are a real attorney and they're very good at what they do. They try to tell them that they are very good, and they are, by the way. In my experience, I've had the best attorneys be public defenders, not private counsels. But still, defendants are skeptical about the skill level of these people. They worry about whose side the lawyer is on when they're working in the work group, and someone's trying to, bend the back of their arm up, basically force them into some sort of disposition. And they're very suspicious of the motivations of the attorney. The attorney might be looked upon as someone who just wants to get this case over with, not to do the right thing by the client. They don't like that, obviously. And there tends to be a lack of one-on-one contact. I mean, it's not unusual in a public defender's office that an investigator will interview the client, not the attorney. You won't even see the attorney until your first appearance in court when they first represent you, which is not even at the arraignment court. It will be the first appearance after the arraignment court. Well, let's look at defense attorney ethics. First, it's absolutely true, and this is true for all attorneys, they must zealously represent their clients in every way, shape, or form, do the best they can for them regardless. They have to abide by the client's decision because it's not the attorney's decision. And there's an obligation of reasonable diligence in doing everything that they need to do for the client. So if there's a witness that needs to be interviewed, they need to go out and interview them. They keep the client reasonably informed about what's been going on in the case so that decisions can be made. There's, of course, confidentiality. These are all important. And, of course, they have to avoid any conflict of interest. So if they let's say they know the victim personally and they're good friends with the victim. That would be a conflict of interest. Okay, let's thinking point. Let's look at these rules. Think about the model rules of professional conduct that the ABA has approved. By the way, the American Bar Association is not a government bar association. It is an association of many other bar associations. It's a private organization. But it does create its own model rules. They're not binding on anyone, but they are often used by actual bar associations as their rules. And so look at these rules and see, are they substantial enough would they be enough to keep these people doing what they're supposed to do? How do they apply directly to all the courtroom actors? And what are the advantages and disadvantages to this ethical model that they've decided on? Or would you change any of these rules? Think about that. Because if you don't have good counsel that's doing the right thing by the client, the whole system's going to fall. Okay. All right, that's it for Chapter 7. Again, if you have any questions, feel free to give me a call, email me, or otherwise, and I'd be more than glad to help.